My Lord, before the adjournment, I was addressing the point which seemed to be exercising my Lord Justice Popplewell, and maybe exercising all of you, about the nature of the, quotes, burden that is involved. And I fully accept that it's a jolly useful bit of shorthand in many, many cases. And every case where there is a specific contract with a specific agreement to arbitrate. But where there isn't, it becomes important that the quotes burden be analysed. And whether, as it were, I think my learned friend at one stage says in his skeleton argument, he refers to a breach of a right, which is an odd concept. Whether what is created is a contingent right or an obligation which is enforceable by a cause of action in damages. And that's why I'm afraid I'm going to bore you, rigid, with an analysis of what is meant by burden, because Mr. Justice Henshaw didn't really do that. Although he cited a lot of authorities, most of which didn't actually support the proposition that he advanced. But I do urge you to think very hard about what is the nature of the burden. And did the states agree, because it is a matter of consensus and contract, did the states agree to the jurisdiction of this court to determine a claim in damages against the states? Now, I would respectfully submit that when one defines burden in those terms, it is impossible to find, construe, to artifice any agreement by the states to that effect. This is where I come back to the conditional benefit principle as creative of a conditional or a contingent right. And this is why when one, I'm assuming that you probably read the critical bit in the J. Bowler relatively recently. I can show you it if you would like to see it.
I have myself.
Yes, I'm grateful. You can see that what Lord Justice Hobhouse, as he then was, said was not that there is a burden on a party to arbitrate, but that there is a right in the party requiring arbitration to protect his own position from being abused by vexatious proceedings. And it's not at all the same thing as a burden on the party who is asserting a contingent right to arbitrate them. And that's why Lord Justice Hobhouse was very, very careful to say that Miss Bucknell's argument, in that case, was not correct because it failed to understand the remedy which was available in the relevant case. The remedy in the J. Bowler was an anti-suit injunction. And in nearly every case, it is. And that is in essentially is, as it were, the normal, leaving aside Section 13 of the State Immunity Act, the normal domestic process which would be akin to the applying for a stay under Section 4, Section 1 and Section 12 of the relevant arbitration acts in the UK. It is a contingent right, and the right of the, without creating a burden or an obligation, the right is on the party asserting that there is in fact no right, not to be vexed. So talk of burden is simply wrong. And the most recent utterance is that in the Atlantic Confidence, Aspen Underwriting, which is in bundle A5 at tab 51. Now, This is really rather an important case, not least because it's a decision of the Supreme Court. And it relates to, among other things, exclusive jurisdiction under Russell's recast. But for present purposes, I'm going to show it to you so that you can see that the notion of burden in the sense of an obligation sounding in damages, that's what you've got to concentrate upon, is not what is the appropriate legal analysis. And you will remember, well, I said you will remember, it was a case, well, have you looked at it recently? The head note, broadly speaking, the Atlantic Confidence went down, and a bank, which was a loss payee under the Hull Insurance, was not party to a settlement agreement which was made between the owners and the insurers, whereby the insurers paid a sum of money to them, among others, the bank as a loss payee. And a couple of years later, it was held that the ship had been scuttled, and the insurers wanted their money back from the bank. And the question was as to the jurisdiction so to order. It arose in the context of an analysis of what is meant by a conditional benefit, when, as in that case, the bank was not a relevant party. And if you could go to page 527, I hope I can deal with this reasonably expeditiously, but it is jolly important in the context of the point that was being put to you by Lord Justice Popplewell. At para 22, the argument of Mr. MacDonald Eggers was set out, and among other things, between E and F, he said, more or less in terms put to me by Lord Justice Popplewell, on its true construction, the exclusive jurisdiction clause extends to an obligation on an assignee to submit to the jurisdiction of the English courts if there were a dispute or claim relating to the policy. That's an argument that was rejected by their lordships. And he goes on to say, he says, 23, I'm satisfied they shouldn't be accepted. And then 24, under EU law, a jurisdiction agreement in a contract will bind a defendant only if there is actual consensus between the parties, which is clearly and precisely demonstrated. Now, as I've already submitted, there is no such agreement which is clearly and precisely demonstrated. And this has an impact, of course, upon Miss Dilnot's part of the case. He goes over page 528 to the second line. Thus, a jurisdiction agreement in an insurance contract does not bind a third-party beneficiary of insurance who is domiciled in a different contracting state and who has not expressly subscribed to the clause. And then at B, nor does such an agreement bind a victim or an insured damage who wishes to bring an action directly against the insurer.
That's all dealing with the position under EU law. He's not saying there that that's the position under...
No, absolutely. But I'm going to show you what he did say about conditional benefit. I'm just putting it in context, largely showing you points that Miss Dilnot will want you to have read. Mm-hmm. But then, at the bottom of the page para 26, the bank's entitlement to receive the proceeds of the policy in the event that there was an insured casualty rests on its status as an equitable assignee. So the bank in that case was an assignee. Per contra, Spain and France, which were not assignees at all. They weren't even such that you could, as it were, properly step into the shoes. They weren't assignees, whereas an assignee would. It is trite law that an assignee transfers rights under a contract, but absent the consent, and this is domestic English law, absent the consent of the party to whom contractual obligations are owed, cannot transfer those obligations. Pause there. The party that he's there talking about is Spain or France. an assignment of contractual right does not make the assignee a party to the contract. And that's even an assignment, let alone the sort of conditional benefit. It is nonetheless established that a contractual right may be conditional or qualified. So its assignment does not allow the assignee to exercise the right without being subject to the conditions or qualifications in question. See what Robert McGarry then said. And then on the facing page, this concept, which has often been described as conditional benefit, is to the effect that an assignee cannot assert its claim under a contract in a way which is inconsistent with the terms of the contract. And then he sets out a number of cases, including, I think, the J. Bowler, which is in the middle. And in my view, the formulation of the principle by Lord Justice Hobhouse in the J. Bowler, where the Court of Appeal approved the use of Sopanoglu, is the best encapsulation. J. Bowler, the insurer, and then he sets out the facts. And then Lord Justice Hobhouse stated at 286, the insurance company is not entitled to assert its claim inconsistently with the terms of the contract. One of the terms of the contract is that in the event of dispute, the claim must be referred to arbitration. The insurance company is not entitled to enforce its right without also recognising the obligation to arbitrate. Now, I would accept the obligation to arbitrate their features, but it's the formulation of Lord Justice Hobhouse related to the remedy. This formulation emphasises the constraint on the assertion of a right as being the requirement to avoid inconsistency, and whether the clause is an arbitration clause, as in the J. Bowler, or an exclusive jurisdiction clause, as in Ewell, it is the assertion of the right through legal proceedings which is in conflict with the contractual provision that gives rise to the inconsistency. Then, in Rouse, the Singapore Court of Appeal, commenting on the J. Bowler and the proposition that an assignee does not become a party to the contract, but would be entitled to enforce its rights against the other party without also recognising the obligation to arbitrate, stated, this approach of entitlement rather than obligation may be more easily reconcilable with the consensual nature of arbitration. And that's why I stressed the importance of identifying the state's consent to the relevant arbitration. This is because the assignee is only taken to submit to arbitration at the point it elects to exercise its assigned right. In the present case, the bank did not commence legal proceedings. I'm going over. And I think...
Well, that was the point in this case. It didn't exercise the right.
No. But it still received the money.
The passages you've just shown us suggest, including that from Rouse at the end, that at the point that the other party elects to exercise the assigned right, it is taken to submit to arbitration. And the agreement to submit to arbitration is expressed in terms of obligation. Now, I quite understand your point that that doesn't mean that they're party to an agreement and that therefore follows that there's an implied promise to abide by the award. But I do still have some difficulty with your submission, which seemed to me to be a separate one, that because the duty to arbitrate, if one can put it in those terms, arises because it's a conditional right in the first place, that there can't be a burden created when the condition is fulfilled. Speaking entirely for myself, it seems to me that this is entirely consistent with that analysis.
Then I've shown you the passages. You've heard my submissions. The question is whether there is an obligation to submit to a claim in damages.
I understand that.
And that's your lordship has that point. I think there are 2 points that I'm making. The important one is that one.
All right.
Anyway, I haven't shown you the intervening passages of largely the Court of Appeal and largely Mr. Justice Morbick and then Lord Justice Morbick, which are all quoted extensively in the judgment of Mr. Justice Henshaw, which I could take you zealously through, but I suspect that would be the most convenient place for you to see them. But you have my submission on what is the pertinent agreement that you have, the pertinent submission to arbitration. And that is all that matters. You ask yourself, did the states agree to being defendants to a damages claim made against them? And the answer is no, they didn't. And what has happened is an artifice created by English domestic law. And I'm none the worse for that, but Mr. Justice Henshaw does at one stage say a particular result would be artificial. And actually, one is then building an artifice upon an artifice. It is only because English law has a concept of equity, which involves the saving of a party from being improperly or unconscionably vexed, that one is in the position one is in. Here, of course, the remedy which was available to the tribunal and to the court was caveated by Section 13 of the State Immunity Act. And I fully accept that there are other remedies available in the event of a contractual, I mean specifically contractual breach of a contractual arbitration clause, as I think Lord Justice Mayles demonstrated in the Airbus case, where it was held that a declaration of right was there an adequate remedy. I'm not saying that the right to an injunction is the exclusive remedy, but it is caveated by the fact that it is protecting a different right from that which is now being sought to be protected by the club, who now assert that there is a positive agreement to abide by the arbitration award and then abide by the judgment. And your lordships, I hope, can see that the logical leap from the abiding by becoming party to an arbitration agreement by means of equity creates a completely different situation from the distinct one, which is a separate agreement to abide by the award. And that's a separate agreement, necessarily. And it has to be, because otherwise, as I said, it would itself be arbitrable, and that would be nonsensical.
You say, Mr. Young, that it arises by virtue of English domestic law. But your claim only arises by way of Spanish domestic law, doesn't it?
Yes, and it may be of interest to you to know that if the club, it's an irony in light of what was said by Mr. Schaff, if the club had bothered to submit to the jurisdiction in Spain and raise this point.
This point being?
There was a pay-to-be-paid clause and an arbitration clause. There was Supreme Court authority in Spain for the proposition that it would have succeeded. So what has caused all of this is the fact that the one remedy which was available to achieve a satisfactory result was the one that was not.
Well, that may mean there's yet another insurance claim, but I'm not sure it takes it any further.
No, I see the force of that. But
and it would have involved giving up what was their right to have the question arbitrated by a London arbitrator, because it would no doubt be deemed to be a waiver of the arbitration clause by submission to the Spanish jurisdiction.
Not necessarily, actually. But this is going on one stage further. But it actually no is the answer. But anyway, not that it matters. But the remedy which was availed by the club was one which did not give it the protection that it was hoping for. And what it's doing now is seeking to make a development of the award, going well beyond the award, seeking to enforce an obligation in damages to which it is impossible to see how the states ever consented. And I do stress the fact that it's a development, because when the club saw fit, it was a matter entirely for them, saw fit to enforce the award under Section 66(2) of the Arbitration Act, and necessarily, as Mr. Justice Hamlin rightly said, the judgment could only be in terms of the award. If they didn't get the relief that actually they now wish they had got, then it wasn't available to the court to give that relief under Section 66. And what they're doing now is saying, we wish we'd got a better form of relief, and we wish then we had obtained that relief from the court under Section 66. That's what they're actually after. And that is based upon an obligation which Spain and France have never consented to. Now, if I can just on the point of the Section 66(2) judgment, this is actually the sixth point. We've got to the end of them eventually. This is about the relevant role of the court. Now, this really relates to Section 9 of the State Immunity Act. And it relates to arbitrations. And yet it confers, in a sense, an immunity which arises in court. Where a state has agreed in writing to submit a dispute which has arisen or may arise to arbitration, the state is not immune as respects proceedings in the courts of the United Kingdom which relate to the arbitration. Now, what that is doing is referring to the supervisory jurisdiction of the UK courts as the courts of the seat. And I know this is a point which I think I developed quite extensively before Mr. Justice Phillips, as my Lord then was, in relation to the function of a court. Here it is plain that the function of the court under Section 9 is only as the supervising court. And the supervising court is, as to quote Lord Justice Moore-Bick in the Svenska case, to make the agreement to arbitrate effective. And you'll remember that there is a passage in Lord Justice Moore-Bick's judgment where he says the final stage of rendering it effective is the entering of judgment.
Where do you get in the section that this relates only to the functions as supervisory court?
Well,
surely the question is simply whether the proceedings relate to the arbitration which the state has agreed to submit.
Well, it's what the Court of Appeal said in Prestige.
Did they have the word only in that position?
They said it's in relation to the the supervisory jurisdiction.
And I quite see that it does. I quite see that it does cover the supervisory jurisdiction of court under the various sections of the Act, for example.
Well,
whether that's
by definition, it can only, if it's been referred to arbitration, if a dispute has been referred to arbitration, the involvement of the court can only be in the supportive role. And it's important to bear in mind that in this case, the jurisdiction of the court which is being invoked is not to support the arbitration, but actually to develop the relief which was granted and to do so extra arbitration, to do so curially rather than by arbitration. But
we know that in cases like AES, the court is enforcing the arbitration agreement, but it's not supervising the arbitration.
No, and this is a point I think also my Lord Mr. Justice Mayles, as he then was, in LR Avionics. Yes. The enforcement of the award is part and parcel of that function, but it ends with that.
But not the enforcement of the agreement.
Well, if the agreement...
and that's the basis upon which the court has power to grant an injunction.
Except that he can't. I mean, you've got to remember, if we're looking at...
Not just the state, no.
Yes.
But we're talking about here now about whether or not you can have proceedings which relate to an arbitration.
Yes.
But which are not supervisory.
Well, hang on, hold on, if you'll forgive me. We're looking at it in the context of the State Immunity Act itself. Therefore, Section 13 is something which is highly relevant. If you'll forgive me saying so. Is it not?
Well, I'm not answering your question.
No,
that's your answer.
I'm hoping that I can answer yours, which is much more important. Yes, if I'm asking you a question, then it's a rhetorical question, and you can give me a rhetorical answer.
Isn't necessarily it's not right to say, is it, that the only proceedings that can relate to an arbitration are supervisory proceedings? That's the point I'm making.
They are supervisory up to the point of enforcement. That's the LR Avionics and indeed the Svenska case. But what it can't do is take what has been awarded and what has been adjudged and then develop it into a separate and new cause of action, which is itself dependent upon the establishment of a completely new agreement. And it's not an agreement to submit that dispute to arbitration that is in question. It's to refer that agreement to court determination. So it's involving a completely different curial function. It's no longer supportive. It is adjudicative. And it's the adjudicative function of the courts which is being enlisted in the arbitration action and the judgment action.
Well, we know, as recently confirmed by the Supreme Court in Enka, that the proper law of an arbitration agreement may not be the same as the curial law, what we've been calling the supervisory jurisdiction. Suppose you had an arbitration clause, the proper law of the arbitration agreement being English law, but it related to an arbitration in France. France was the seat, and the French courts. Now, if you brought proceedings in England for a declaration as to the scope of the arbitration agreement, and that governed by English law, would that not relate to arbitration, even though you were asking the English court to do something which wasn't part of the curial or supervisory function?
I'm just momentarily going to reflect upon that, my lord, if I may. If the seat is France, you cannot commence proceedings in England because, in fact, as Mr. Justice Phillips decided, it's not for, in a case involving Pakistan, remember, you cannot invoke proceedings in another jurisdiction because the proper proceedings have to be brought in the courts of the seat. So the example
that you mean by the proper proceedings.
Well,
the curial supervisory proceedings do. What about questions about substantive rights under an English contract?
Because the seat is France. You would have to bring the proceedings in France and have evidence of English law. And the only place you can actually do that is in France, because that's the seat. Or to do it the other way round, if the proper law of the arbitration was French but the seat was English, you'd have to bring the proceedings in England because that's the curial, and as per Mr. Justice Phillips, that's the court of the seat. But it would have to hear evidence about the law of France, or in Mr. Justice Phillips' case, the law of Pakistan.
Well, it wasn't really me; it was the Court of Appeal in
C&D.
Yeah.
Yes, I think, but it was a case that your lordship will have remembered and actually took C&D and then developed in that context. But your lordship will remember. Sorry, this is a case which is not before the court. I'm not sure it even got reported anywhere, but it was a case where there was an LCIA arbitration with an English seat as determined by the arbitrator. And there was an issue as to whether that was lawful under a contract which was expressly governed by the law of Pakistan, because under the law of Pakistan, you could not actually allow such you could not exclude the jurisdiction of the Pakistan courts. And following C&D, Mr. Justice Phillips said, no, the law of the courts of the seat are the ones which have the exclusive, I think it was exclusive right, to determine the propriety of the attack on the arbitration award, which was itself part and parcel of the supervisory jurisdiction. So, I mean, I'm sure I can dig your lordship's judgment up, but it was founded upon C&D.
But the broader point is whether proceedings which relate to the arbitration refers only to the court's exercise of its supervisory jurisdiction,
Well,
and whether or not the examples given so far.
Well, if your lordship,
it seems to me that the language of Section 9 is wider and not so specific. You could have, for example, proceeding. I don't know whether this would turn out to be a good example or not. We mustn't get diverted by it if it's not. But you could have, for example, proceedings which are to do with whether an award should be disclosed to a third party.
That's the curial. That's for the seat. Only the courts of the seat can do that. But perhaps
so you can't seek disclosure in this country of a foreign award.
Yes, of course you can.
But I thought you said that was a matter for the courts of the seat.
No, it could be. It could be. You can seek.
But you're saying the court wouldn't be exercising any jurisdiction. It would be allowed to exercise because it's always a matter for the curial court to deal with matters.
It always is
of disclosure.
ultimately. It always is ultimately. It could be. It could be. In the example given by my Lord Justice Males, you could have an application to the seat court to say this application should not be brought in England. But perhaps I'm not wanting to get unduly tied down. Unduly involved at a point that is at the level at which your lordships are looking at it, significantly academic. Your lordship said, is it limited to supervisory jurisdiction? And if I could just ask you, you don't need to pick it up now, but that's what the Court of Appeal said in paragraphs 56, 66 to 69 of the Court of Appeal judgment. Perhaps
in Prestige number 2.
Yes. In the interests of expedition, can I just ask you to look at that? They make it perfectly plain that Section 9 is looking to the supervisory jurisdiction, and not, as it were, a developmental jurisdiction, which is then to extend the arbitration award or judgment. But I would accept, as I have already accepted, that supervisory jurisdiction extends to converting the award into a judgment under Section 66(2).
Which was that?
Yes, I said that.
That's number 2. They were only concerned with
yes.
a claim to exercise the supervisory judgment. So they may not
yes, but
their mind on whether it's wider.
No, well, if it's wider, it makes no sense of Section 9, because by definition, the agreement that you're looking at is an agreement to submit a dispute to arbitration, whereas the agreement which my learned friend Mr. Hancock is now asserting is an agreement to refer to the courts, to exercise the court's adjudicative jurisdiction to award damages. It's the wrong agreement. And there is no doubt about it that once one engages in essentially in the artifice of the implication of agreements, you have to be very, very, very careful about what agreement it is you're seeking to enforce. And here, the only agreement that is material is the agreement to submit disputes to arbitration, which by definition cannot include the dispute to honour the award, for the reasons I've already given, circularity and whatever. And
Well, the states have agreed in writing to submit a dispute to arbitration, and that's the dispute which was referred to Mr. Schaff. So,
correct,
so
that's the
so
one.
holds the prestige number 2. So is the question then whether the present proceedings relate to what we might call the Schaff arbitration?
Yes, and by definition it relates to the award, and that is where, albeit in relation to section 3, the decision in Svenska and NML become important, because it would be difficult to contemplate that more or less identical words in section 3 have a completely different meaning in section 9. And the answer is, it's a cause of action arising out of the award is not a cause of action arising out of the arbitration agreement. It's arising out of a distinct agreement. And that's why in Svenska, if you'll forgive me, that's why the court held, and the NML have held rightly, that a claim on an award is not a claim related to the underlying arbitration, something else, and therefore it falls outside the exception of 3.1 3.1a. Sorry, momentarily lost my track. Yes, it's 3.1a, related to. It will be very difficult to construe the notion in the State Immunity Act related to or relating to as being of a different meaning. Admittedly, one's a past participle and one's a present participle, but otherwise it's the same. And Svenska, which once again I'm assuming that your lordships have looked at Svenska and NML, and I'm going to say, if you want to see any of these cases, please tell me. But it was held by Mrs. Justice Gloucester and upheld that an application to enforce an award was not an arbitration. It was not an application relating to the underlying arbitration agreement. Quite rightly so, and 4 of their lordships in NML have said that's right. You give a narrow meaning to related to. Once you have the intervention of an award, or in our case an award and then a judgment between the arbitration and what is being done in court, then you no longer fall within the exception.
Well, except for section 9 is not concerned with relating to the underlying arbitration agreement, but perhaps more broadly with relating to the arbitration.
But the same is equally true. It's the same as equally true. It's not relating, it's relating to the arbitration, not the award. And it's very clear that it does not say relating to the award. If it had meant the award, it would have said the award. Well, that's my submission, and that's actually one of the things you've got to decide. Poor chaps. That's the issue. And it's a jolly important one. And I would respectfully submit, Svenska it's not formally binding on you in the sense that there was just a very powerful obiter dictum from the court in Svenska and a very powerful obiter dictum, subject to whatever cross on precedent would say, obiter dictum in NML, saying relating to or related to is to be given a narrow construction. And that once you've got things which interpose between the two relevant notions, then that breaks the relationship.
Anyway, your submission is that relating to means the same in section 3.1a and section 9.
Well, one is, as I say, related and the other is relating, but I suggest that they have the same effect, yes.
And accordingly, if the club are right that NML and Svenska are distinguishable on the grounds that here the cause of action, which is relied on, involves not just the source of obligation, which preceded the award, but subsequent conduct as the breach, which is also a necessary ingredient. If they're right on that, then it comes within section 9 just as much as within section 3.1a.
Only, not in relation to the judgment claim and the award claim. It might, I accept, it might with regard to the Section 18 application, but not the judgment claim.
Why not the award claim? If they're right in saying NML is distinguishable, because that was all about adjudicating on the elements of a cause of action which preceded, in that case, the judgment in Svenska, the arbitration. Whereas it is said here, in order for the claim on the award to be made good, they say we have to establish, one, that there's a source of the obligation, leave aside at the moment whether it's contractual or whatever, or whether it's right, but there's a source of the duty to abide by the award, and, because they're claiming a monetary loss, there has been a breach of it. Both essential elements of the claim, cause of action as we would describe it in an English analysis. And the second of those postdates the award. Now, if they're right in saying that's a relevant distinction, so that
it still doesn't
the facts that are relied on for breach
still not related to the arbitration, though. I mean, if you say that Svenska and NML are wrong rather than distinguishable, I can see that may be so. But if you just say it's distinguishable, it doesn't seem, if I may respectfully say so, to answer the question.
No, I'm confusing myself. There we're talking about relation to the commercial activity.
Yes, but it's the same
to the arbitration.
It's the same relation. It's a narrow meaning is given to related to, and as soon as you relate what is the proceedings in respect of which there's an issue about immunity to something other than that which it's expressly related to in the Act.
All right. Thank you.
I hope that I'm not for one moment pretending that this is analytically or intellectually an easy exercise. I have spent weeks, literally weeks, pondering on it, and it's essentially founded upon the conditional benefit issue, but it develops most acutely because it has to be said that the State Immunity Act cannot have contemplated what's actually happening now. The State Immunity Act was, in principle, dealing with the simple case of state as a party to either an arbitration agreement or a commercial transaction in the paradigm as the paradigm, rather than as the upshot of the operation of an English doctrine, which hadn't then been developed. So if you think that I am suggesting that this is a simple exercise, no, I'm not. I fully accept that it is jolly difficult, and that's why I'm constantly, and I'm afraid tediously, I'm sure, asking you to focus upon what it is you are actually having to focus upon, and focusing upon avoiding the abuse of convenient shorthand, which may be entirely appropriate in the paradigm, but is much more difficult in this case, where there simply is no agreement. No agreement to arbitrate, although one has been found in relation, by virtue of Section 82(2), to apply to the conditional benefit, the exercise of a right, and the converse of that, which was the club's claim in the arbitration before Mr. Schaff. So I'm afraid I've probably made it sound intractably difficult. That's because it is actually jolly difficult, conceptually. But you do have to ask yourself, just go back and ask yourself, has Spain ever, or has France ever agreed to submit the claim against it to arbitration? And has Spain and France ever agreed that the English court would have jurisdiction? And I respectfully submit that when you look at it like that, when it's no longer looking at the arbitration agreement that has been been found by the Court of Appeal, but a distinct one, which it has to be necessarily, then you really just can't find it. There isn't one. Spain has never agreed, nor France ever agreed. As I say, I don't pretend it's easy.
Right, well, if those are your 6 observations, and we've now worked our way through them, is that the main course completed, or where are we going now?
You remind me of Mr. David Donaldson before the House of Lords. Do you know this story?
I'd stop there, Mr. Young.
Do you remember the story there? You've got to have your greens before you get to your pud. I've finished my 6 points. I'm now going, I hope, relatively speedily, I hope, to go through the judgment of Mr. Justice Butcher. I'm going to start with Mr. Justice Butcher and deal with Mr. Justice Butcher, and then turn to Mr. Justice Henshaw, because, in a sense, a lot of the points will be similar, if not the same. But if I try to deal with the way it's done in my skeleton, which is by reference to sections, I found it became unnecessarily difficult to get one's brain around, particularly because the nature of the cause of action on the award and on the judgment is definitionally much more complex than the Section 18. My Lord, looking at Section 9 in the judgment and awards claims, and you will remember that States won so far as the judgment claim is concerned, but lost so far as the awards claim is concerned. And that's a point that is going to be developed by Still not. Now, I start with the proposition that, and it has been established by the Court of Appeal in this case, that there is no arbitration agreement in writing to which Spain is a contracting party. That is indisputable. And the states have not agreed in writing to submit this claim or this dispute to arbitration. Nor indeed have they agreed to submit the club's claims for relief as now is sought to arbitration. By definition, as I've explained ad nauseam. It is true that there is an arbitration agreement in writing between the club and the membership owners. It is true that the Court of Appeal has held that with regard to the state's claims against the club, the states were held to be making a claim under or through the member. And thus, for the purposes of Part 1 of the Arbitration Act, the states were within the definition of a party to an arbitration agreement. Part 1 of the Arbitration Act does not relate to claims derived from, or more importantly, developed from, arbitration awards or judgments. So there is a very limited respect in which one can even colourably mount a case that states are party to any relevant arbitration agreement. Now, as I say, the courts are being asked to exercise an original adjudicative function, not a supportive or an enforcing function at all. So my Lord, Mr. Justice Mayall's cases like Norrie and LR Avionics are absolutely right, and I've got no problem with them because they were just enforcing what had been awarded. This is a case where what is being sought from the court's distinct independent adjudicative function is a determination of a different order from that which has been referred to arbitration. That's critically important. And the function, as I've said, of the court's operations under Section 9, I've made this submission, whether it's right or wrong, is that of supporting an arbitration, not of developing it. Now, what Mr. Justice Butcher held was at paragraphs 52 to 59 of his judgment. One may think that in an appeal against a judgment, the first time it's referred to as being on the afternoon of day one, somewhat unusual, but 52, it's page 18 of the judgment. Mr. Justice Butcher reasoned that the awards claims were different from the judgments claims. He said that the judgment claim was outside the Section 9 exception because of the interposition of the judgment between the arbitration and the action which the club asserts an obligation arising out of the judgment and not anything to submitted to the arbitrament of Mr. Schaff. And that was right, both as a matter of analysis and as a matter of the application of the reasoning in Svenska and NML. And that is why, paragraph 58, he distinguished rightly the case of an action to abide by a judgment. That's simply not in any way materially related to any agreement to arbitrate. And that was right. But he said the award was different because the award did not interpose itself between the arbitration and the claim. Now, with the greatest of respect, that's where I do take issue with him. When in Svenska, it was held by Mrs. Justice Gloucester, supported by the Court of Appeal, supported by the House of the Supreme Court in NML, that where you interpose the award between the arbitration and the claim that is then being determined by the court, there is no longer any sufficient relation. Now, it may be that, as it were, the multiplicity of interpositions, that the award being interposed doesn't generate immunity, but the award plus the judgment does, may be regarded as a matter of some intellectual refinement. It is important, I think, to realise that the point that was made so clearly by Mr. Justice Flo, as he then was, in Sonatrach and Statoil, and if I can just show you that, because it's a case which momentarily lost. It's a case which sets out. Oh, I know. Sorry, I was looking at the wrong bundle. It's bundle C. No wonder I couldn't find it. Bundle C, tab 29. Société pour la recherche, la production.
Bundle C, please.
Bundle C of the bundle 2 of bundle C,
Thank you very much.
and it's tab 29. Sorry, it's not often you have authorities bundles going to three groups. It's not helped by the fact that it's not called Sonatract in this report. It is in Sonatrack. It is in the Lloyd's, but not this. Société pour la Recherche, Sonatrack against Statoil. Now that was, as my learned friend will doubtless tell you, that was a case about the award of interest, which wasn't made by the arbitrator. But the question was what jurisdiction the courts had to award interest when the arbitrator had not exercised its power under Section 49. And Mr. Justice Flo held, following judgment of Mr. Justice Cook, that it was not possible to award interest under the Arbitration Act for the court to do that. But what the court could do was enter the judgment as a judgment and then apply the judgment debt interest rate rules. And the critical point is, I think, I hope I can take you to the relevant bit, is page 875. Paragraph 55. Once a judgment on an award has been entered under Section 66 of the Arbitration Act, 101, the judgment has the same characteristics as any other judgment of the court, and interest will run under the Judgments Act from the date of judgment. That is the interest which Mr. Justice Cook awarded here. Miss Heilbronn sought to suggest that there was some tension between Section 49(4) and Section and Section 66, or between Section 49(4) and the Judgment Act of 1838, as amended by the Administration of Justice Act. However, I do not consider that there is any such tension. Once a judgment is entered under Section 66, a different regime to that of the arbitration itself applies. Since the obligation to honour the award merges into a judgment debt which carries interest at 8% under the Judgments Act. This was a point made by Mr. Justice Carr, as he then was, in Dalmere Cement. The same point was made in a modern context by Mr. Justice Beatson, as he then was in Gator. An award, said Mr. Justice Beatson, may be either enforced in the same manner as a judgment, Section 66(1) and 108(1)(2), or a judgment may be entered in terms of the award, Section 66(2). The leave of the court to enforce the same manner as a judgment is a prerequisite of the power to enter judgment in terms of the award, but the two are separate. The essential difference is that the obligation to honour an award arises by virtue of the agreement of the parties, whereas in the case of a judgment, it follows from the power of the court. This difference is reflected in the approach of Mr. Justice Akins in two cases, and then he sets them out. Now, the important point there is that, and this may be, in a sense, it may be as apt to deal with the specific jurisdictional serious issue to be tried questions, but when the club opted to enter judgment, it then, on the award, and in the terms of the award, it then merged any cause of action arising out of the award in the judgment. Now, it has to be said that the learned editors of Flannery on arbitration have questioned that. As you've seen from my skeleton argument, every other learned textbook has accepted it, and it's consistent with what Mr. Justice Carr held in Dalmere Cement. That the cause of action then does not arise out of the award at all. It arises out of the judgment. And it's the interposition which is what is critical. And that's where Mr. Justice Butcher, if I may respectfully say so, introduced a tension in his reasoning, which was ill-adapted when the award on the judgment involved the interposition of the judgment. Likewise, the award on the award, the claim on the award the claim on the award involved the interposition of the award. So on either way, and this does have to be decided, I would respectfully suggest, on the balance of probabilities, because it relates to Section 9, you have to say that there is an agreement to abide by an award which was in any way colourably related to the matters of which complaint is now made. And the answer is you can't. Because there is no agreement to abide by the award any more than there is an agreement to abide by the judgment. The fact is that the club seemed fit to enter the award as a judgment and to get Section 66 to judgment. And that was their own free choice. Now, my learned friend, Mr. Hancock, will rely upon a case in Hong Kong, which he will doubtless show you. But I think I can perfectly simply deal with it. It's a case called Jarmen. It's in the supplementary bundles. But that was a case where there was enforcement at common law. There had been a summary entering of judgment, but the Court of Appeal below had held that that did not, in the circumstances of that case, amount to an election to proceed by way of summary judgment, and it did not, as such, exclude the right to proceed in common law. That then led to the claimants in that case seeking to enforce the award at common law, and it was held then by the court, which contained Lord Sumption, that the court had the jurisdiction to give further relief from that which was actually awarded. But that's because of the nature of an enforcement at common law. Now, in the present case, my learned friend, Mr. Hancock's clients, have never sought to enforce at common law. They have only ever sought to enforce under Section 66(2). And that, as we've got in the clear statement by Mr. Justice Flo, amounts to the merger of the award, of the claim to enforce, to abide by the award, being merged into the judgment.
Sorry to keep interrupting you.
No, I want you to.
Sartrek was concerned with an award for an amount of money, and it's referred to as a judgment debt. But
yeah.
How does the doctrine of merger work for declaratory judgments in general? Leave aside any arbitration.
Declaratory judgments or awards?
Well, declaratory judgments.
Yeah.
So if I have a contractual dispute and I seek a declaration that my counterparty is in breach of contract, and I get a declaration to that effect, does that mean that actually my counterparty is no longer in breach of contract because it's extinguished
my
contractual rights?
Not at all.
Well, then what's the cause of action that merges into a judgment when you have a declaratory judgment?
I would say two things. The first is that in the example that you have given, it is almost certainly assumed by your lordship that the arbitration, the arbitrator is not functus.
My example doesn't have an arbitrator. I just bring a High Court action as owner asking for a declaration that the Charter is in repudiatory breach of my charter party. Because I want to know whether I can terminate and get damages, or I'm going to have to withdraw for payment of her. And I seek a declaration to that effect, and the court holds, I declare that the Charter is in breach of the Charter Party. Does that stop me bringing a claim for breach of Charter?
It does stop you from bringing a claim in the courts. Yes.
No, there's no arbitration in this. Forget arbitration.
I see. I'm sorry.
I'm not on arbitration at all.
I'm sorry. I'm thinking of Section 9.
No, I'm not on arbitration.
Sorry.
I'm simply trying to identify what the nature is of the operation of the doctrine of merger. If your judgment is not a judgment awarding a money sum, but is a declaration of rights.
Yes,
which is what we have in this case.
Yes, do forgive me, my lord. I was applying Section 9, which relates to arbitration. So I'm afraid I've got the wrong set of assumptions.
So, at the moment, I don't find it easy to see how anything merges into a declaratory judgment.
No, the point is. The point is, my lord, in the example you've given me, there is no question of merger into the judgment because you're not dealing with the cause of action on an award. I am considering the cause of action on an award, so I'm looking at it from the point of view of Section 9 and where there is an arbitration. I have to. Otherwise, simply to say, well, there's a judgment of the court, that there's a declaration, and that is there's no separate step between the court giving judgment and the judgment being entered, which has any materiality. Therefore, yes, there's no merger. I would agree. But the question here is what happens, given that there are two separate actions, and only the arbitration claim at the moment is able to proceed, at least for the purposes of Section 9, you've got to ask yourself, what has happened to the cause of action in the on the arbitration award, even assuming that there is otherwise an obligation to honour it? That's why I'm sorry, it was my fault entirely for not getting your lordship's assumption, but bearing in mind that we're talking about Section 9, you have to have that. If I'm not right about that, then I welcome being corrected. But if the arbitrator has made an award and it's entered as a judgment, then any action on the award has ceased, and you can have an action on the judgment if you can. But in the situation where, let's say, I, an arbitrator, make a declaration that the charterers were in repudiatory breach of contract.
But you say if you can. I think it's your case that a declaratory judgment, which is a judgment which replaces a declaratory award, does not itself confer rights to claim any damages for breach of that contract.
But what you do,
where does the ability to sue for damages?
Well, the example that you gave me is, let's say, a charter party where the charterers have repudiated.
Yes.
I, as an arbitrator, have said the charterers are in repudiation. I reserve my right to make an award of damages. The solution is self-providing. What we have, however, is where the arbitrator was not invited to do that. And indeed, if Mr. Schaff had reserved his jurisdiction, then it would have gone back to him potentially to achieve what has now been put before Sir Peter Gross. The problem then is, well, what has happened to the first arbitration, which then generates the need for a Section 18 for a completely separate arbitration? And I don't think, in the example that your lordship gave me, if I may respectfully say so, you've got to keep in mind that you're talking about an arbitration agreement which sets the ball rolling. But once the ball is set rolling, the award is produced, there is no action on the separate action on the award if it's entered as a judgment, because then the only action is on a judgment.
If an award, a New York Convention award, has been made and has been enforced in another common law jurisdiction by way of entering judgment, would that be an answer to an attempt to register enforce a judgment, enforce the award in this jurisdiction?
Yes, it probably would be, because it is no longer subject to the proof of the foreign, as it were, the seat where the judgment was enforced, if it had the same doctrine of merger as we do have here, as we've got it.
Why isn't that one of the grounds recognised in section 103 then? The refusal of recognition or enforcement?
Because it doesn't need to be. Because it has ceased to be. Let's take it in easy stages. If by the law of the foreign state there is an award and it is enforced and becomes a judgment, and there is, let's assume there is a notion of merger under the law of that state, then there is no award, and the judgment can be enforced in this country under the Administration of Justice Act, or indeed by an ordinary action on the judgment. But it's not related to the arbitration.
That would rather undermine the efficacy of
No, not at all.
New York
Not at all.
convention awards around the world.
No, quite the reverse, actually. A lot of people, I know this, I'm probably giving evidence, a lot of people specifically do not want to have an award entered as a judgment, precisely because they want to be able to enforce it under the New York Convention. So it's what we have here is the club very actively entering it as a judgment because it specifically wanted a judgment in order to resist enforcement under the Brussels reg. So it is something that parties are very acutely aware of, my lord. Yes. If you want to have something that is easily enforced, keep it as an award. I mean, take it, for example, enforcing awards in China. The one thing you do not want, and everybody knows this, you do not want your award converted into a judgment, because you can't enforce judgments in China, but you can enforce awards.
I understand the point.
So it's the choice of the party with the benefit of the award. And if he chooses, then he chooses. The reason why in the Germain case he didn't have that effect was because it was held that there had not been an informed election. And therefore there was no relevant knowledge on the part of the party that sought the summary enforcement. But my learned friend will show you the case, and I hope I can deal with this relatively briefly in reply. But you can see that it's a very different case. It was, just briefly, Germain was a case about an award which required continuing performance of a particular undertaking, and that was ordered, and then there was an act that was entered. That award, effectively, of an injunction, of mandatory injunctive relief, was entered as a judgment under the summary procedure. It wasn't effective as a matter of the doctrine of election, and therefore the question was as to how the enforcement procedures under the common law took effect. And the court, the High Court there, the highest court there, held that you can get further and better relief on top of an award if you enforce at common law, but not if you enforce under section 66(2). And interestingly, the court in that case actually referred, without any disapproval, to the judgment of Mr. Justice Flo in Sonatrach. So the simple point I'm making is that Mr. Justice Butcher was quite right to say that the interposition of the judgment between the arbitration and the present judgment claim excluded Section 9 exception. But he was wrong to say that it did not have that effect with regard to the arbitration award, A, because the award was under Svenska was itself an interposition, and B, because actually before there was any liability in Spain, the award had been entered as a judgment. And that was why I gave your lordship the brief introduction on the chronology, that there was no liability while the award was in the 8 months or 3 months. The award had its own independent existence. So it's my respectful submission that the analysis of the learned judge, which excluded the judgment's claim on the basis of interposition, was entirely correct. His analysis with regard to the award's claim was not, A, because the award was interposed, and B, because the cause of action on the award merged in the judgment, and therefore it is no longer an extant cause of action. So he was right for the judgment claim, but wrong on the awards claims. Now, I do not pretend that that is the answer to this case, because we've still got section 3 to deal with. But Mr. Justice Butcher referred at paragraph 55 or actually I go back to 54, and at one point I think he's knocking down a straw man. No, I think I've probably got to go back to 53, I'm sorry. The fifth line, halfway along it, line beginning Hamlin J. Fifth line, the award claims are based on the alleged breach of what the club contends was the implied obligation on the states to honour the resulting award. That obligation, as I set out in more detail below, is said to arise in contract or as a substantive equitable obligation or as a matter of statutory duty or common law. As I say below, I consider that that case raises a serious issue to be tried. Pause there. That's the wrong standard for the immunity point. Those claims can, in my judgment, be properly said to relate to the arbitrations to which, as found in the Prestige, the states agreed to refer the disputes as to their entitlement to pursue their claims. He does not there consider the significance of the meaning of relation in section 3 and how Svenska operates elsewhere in those exceptions. The relationship arises from the fact that the award claims depend upon there having been an obligation on the states to honour and give effect to the arbitration awards which arose by reason of the submission of the relevant disputes to arbitration, which he has said only there's a serious issue to be tried. That's wrong, I'm afraid. He's got to decide, for the purposes of section 9, whether there was a relevant obligation. But then he goes on, the facts that the claims made in the present award claims were not themselves submitted to that arbitration, and that arbitration is over, are not, in my view, answers to this. Section 9, the Act, can apply in relation to proceedings concerned with arbitrations which no longer extant, where the tribunal is functus. And then he refers to LR avionics, to which I completely agree, because it is part and parcel of the process of the curial function, of the seat function of the courts to enforce the award. So that's why I say it's a straw man that he's addressing there. And I never said that the arbitration had to be extant. But what I do say, the function of the court is different. And then he says, the states also contended for the enforcement of the awards had been concluded by their embodiment in the judgments of the court pursuant to the Club Section 66 application, referred in particular what was said in paragraph 117 of Lord Justice Morbick in Svenska. And then it's the passage which is quoted, and it says, it's the last line on that page, one aspect of its recognition and as such is the final stage in rendering the arbitral procedure effective. That's Lord Justice Moore-Bick, who is actually commenting on when the Section 9 function of the court ends. It's, yes, the arbitration was extant, yes, the tribunal was functus, subject to any remission to him. But the function of the court for the purposes of Section 9 is then exhausted. There is nothing more for the supervising, enforcing court to do once judgment has been entered. And purse on a track, there is no longer any action on the award that is possible. Still less an action to honour the award because that's all been embodied in the judgment. And he then says, the states emphasise the words the final stage and contend that no proceeding subsequent to the enforcement of the award as a judgment can relate to the arbitration for the purposes of Section 9. In my judgment, that is to read too much into what was said in that paragraph. The Court of Appeal was not concerned with an action based upon a failure to comply with the implied obligation to honour an award. Note that as to where that originates from, what contract. Nor was it addressed with the complex arguments with which I have been presented as to the relationship between the sort of action and the statutory methods of enforcing awards under Section 66 and Section 101, and whether the former can survive enforcement of the award under the latter. The distinction which the Court of Appeal was making in the context of that case was between steps to secure recognition of the award and thus make the arbitral procedure effective and process in respect of property for the enforcement of an award, which is dealt with in Section 13 of the SIA. I therefore don't consider that Svenska answers the issue which arises for decision as to whether Section 9 means the states are not immune as respects the awards claims. I would, however, add that in terms of para 117 of Svenska, I conclude that the claims made in the award claims can be said to be a step aimed at rendering the arbitral procedure effective. No, the arbitral procedure was made effective when the judgment in terms of the award was made. That was the end of it. There was nothing further that anybody had referred to Mr. Schaff, or the club at least. They hadn't referred to anything. They got their award. They got such declarations as Mr. Schaff was prepared to give. And he must, by definition, have been functus, because otherwise the Section 18 application is completely misconceived. If Mr. Schaff was not functus, then there was no scope for a Section 18 application. At some point, the club has abandoned the Schaff arbitration and is going for the Gloucester Gross arbitrations. So the Schaff arbitration must be history. And it has achieved everything that they asked for, which was the declarations made by Mr. Schaff. And the court has embodied that in a judgment in precisely the same terms. There was nothing left of the agreement to arbitrate that dispute. Nothing at all. And that is why I say the interposition point must mean that whilst the learned judge was perfectly right about the judgment claim, he is wrong about the award claim. And I would submit that Section 9, whilst it may undoubtedly, possibly, I'll deal with this, have some relation to Section 18, subject to Mr. Schaff and the like, it cannot, simply cannot, engage the operation of the arbitration exception in Section 9. That's it in a nutshell. Your Lordship has it in greater detail in my skeleton argument, and I hope I can proceed to leave it at that at the moment. I mean, that is essentially what our case is. Lordship, I've got several pages of notes further on this, but I'm anxious of the passage of time. So if you could give me just 2 minutes, just so I can cast my eyes over
Yes, all right.
whether there's anything. I think I'm repeating myself, in which case you'll tell me.
Oh, well, if you think you're about to repeat yourself, I would say don't.
I'd rather repeat myself than making the point, just in case I've not made it properly
All right,
before.
let's hear it.
The court is not concerned with the merits of what has been submitted to the arbitration before Mr. Schaff. The court is concerned only with the consequences which ensue from the award, and indeed the entry of the judgment, which necessarily involves a different dispute about different relief arising out of a different contractual relationship. And the relief sought is entirely different from the relief granted by Mr. Schaff. And it cannot, therefore, be that there is anything other than an interposition of the award, because by definition, everything that Mr. Schaff was going to give has been given already, and what the club is now after is something more. Now, if that's been referred to arbitration, then it was referred to arbitration before Mr. Schaff, and he hasn't given it. If it wasn't referred to arbitration, then Section 9 doesn't apply at all. I think it's a variation on a point that I've made, but I think that's it in a nutshell. Yes, I think I've made all of the other points. If the need to reply, I will still bear in mind the words of Sir David Cairns.
Yes.
Prefaced by the words Mr. Hobhouse, as your lordship well knows. Turning to Section 3, if I may, and reminding you that the Court of Appeal below was concerned only with Section 3.1b, not 3.1a. Now, 3, which is, one might think, slightly odd, my learned friend not even to have run it. However, that's a matter for him. A state is not immune as respects proceedings relating to a commercial transaction entered into by the state. Now, one considers the term transaction. I think the OED, I had a little look at the OED, and it talks of business dealings, carrying or handing or taking over, and carrying out or conducting the performance of a piece of business, carrying through performance of a conduct of a business or an adjustment of a dispute by mutual concession or agreement, the carrying on completion of business or a piece of business. It's all to do with the word transaction is inevitably founded upon a consensual business arrangement, in my submission.
But that's widened by 3C, which extends it to activity
I agree.
engaged in otherwise than in the exercise of sovereign authority.
I completely agree. I hope I've not shied away from this. But Section 3.3 says any other transaction or activity, brackets, whether of a commercial, industrial, financial, professional, or other similar character, close brackets, into which the state enters or in which it engages otherwise than in the exercise of sovereign authority. Now, what matters for your lordships, and this is the point that I made earlier, and I was told that it hadn't been adequately set out in my skeleton. Well, let me make it adequately now. If it's a good point, then it's a good point, and if it's a bad point, then it's a bad point. But I would respectfully suggest that you have to ask yourself, was the making of a claim for criminal injury compensation in criminal proceedings by the state prosecutor commercial? No, it's judicial. Was it industrial? No, it was judicial. Was it financial? Well, maybe. Was it professional? No, it was judicial. A similar character. Now, we don't see there the time-honoured phrase, the time-honoured word whatsoever. We all know how the eostem generis principle can or not apply. I would suggest that what has to be clear, and it has to be clear for the reasons I've indicated, is that the activity or transaction engaged in by the Spanish prosecutor getting judicial award of criminal injury compensation has a similar character to one of those four preceding words. It doesn't say, as it might do and my learned friend wants it to do, anything that the state does other than in the exercise of sovereign power. It doesn't say that. It's much more specific. It's identifying the nature of the activity with a sweep-up derived from similar. And if a judicial proceeding is similar to a transaction of any form, commercial, industrial, financial, professional, then obviously I'm wrong. But I would respectfully submit that an application to a court to make an order simply isn't similar to any of those preceding four words. And I mean, that is in effect what my learned friend is saying. One has to dismantle his Ben Carbuche argument. And it is that the Supreme Court in Ben Carbuche, he says, held in relation to a completely different section relating to employment contracts, that there was no immunity because there was an exclusion of the right of the disemployed person to a fair trial under Article 6. And therefore, the only way you could effectively disapply Article 6 was if it was proportionate to do so. It is proportionate to do so if it is consistent with international law, by which is meant customary international law. If it is consistent with customary international law, then it is legitimate, and it is not a breach of Article 6 to apply immunity in that case. So what my learned friend says is, well, if there's any activity at all, if it's not Jure imperii, then there is no exception. There is no immunity. That is not what has been said here. And indeed, when one looks to see how the other statutes which have been made by other states. Let me just give you a taster. Let's say tab 11. Let's take tab 11 if we may. This is Australia. And section 11, which is page 7. And this is why you're looking for what is customary international law, what is accepted. 11 says, foreign state is not immune to in a proceeding, so far as the proceeding concerns a commercial transaction. Section 3, in this section, commercial transaction means a commercial trading business or professional or industrial or like transaction into which the foreign state has entered, or like activity in which the state has entered, and without limiting the generality of the foregoing includes. Nothing is there said about Jure Imperii, which is what my learned friend says. When one looks, so we would say, well, customary international law is reflected in the Australian statute, shows that actually it's only specific commercial transactions recognizable as such that are within the exception. When we look at, for example, then the next one in 12, which I think is Canada, and that's at page, I can't read it, 3, bottom, tiny, tiny numbers. And it's section 5, the left-hand column. The foreign state is not immune from the jurisdiction of the court in any proceedings that relate to any commercial activity of the foreign state. And in French, qui porte sur les activités commerciales. You know, it's specific to commercial. It's got nothing to do with commercial, but it's actually anything that isn't jus imperii. So that shows you what customary international law is. Let's look at the next one, which is Israel. Page 2. Section 3 at the top. Exceptions to immunity. A foreign state shall not have immunity from jurisdiction where the cause of action is a commercial transaction. So, just taking that spread, you can see that the requirement that it has to be jus imperii is not part of customary international law. 3 very major states do not so require. And this is where I mentioned the issue of the burden of proof earlier, because if my learned friend wishes to make good his case upon Ben Carbush and the way that Article 6 operates by reference to the proportionality of the immunity, then he needs to show that customary international law extends beyond commercial activity. And he can't do that. He doesn't do that. And indeed, Ben Carbush doesn't say it. What we have is that the extent of customary international law on the operation of immunity is limited to commercial activities, not commercial activities of the sort that my learned friend is seeking to engage in. So in my respectful submission, it is entirely appropriate for you to read or other similar character as being significantly governed by the preceding adjectives. And if judicial criminal injury compensation is not similar to any of those, then I would respectfully submit section 3(1)(a) doesn't apply. I put a question mark by financial, but in my respectful submission, in the context of the 4 specific exceptions, financial must mean transactions relating to the financing of business and the like, and not simply the recovery of damages by way of judicial proceedings.
But subsection C refers to transactions or activities, two separate.
I agree. I agree. I wouldn't.
The words that you're focusing on
I've got no problem.
qualify each of them. So I'm not following at the moment
Well,
why what's within the scope of activity should be in any way confined or constrained to what amounts to a transaction.
Well, I say that it's dealing with activity because it may be something other than, it may be, let's say, the provision of a guarantee for some other state enterprise. I agree the word activity is there, but it's defined, I would respectfully suggest, by the words in brackets. You get the words which precede are given colour by the words in parenthesis, and importantly the word similar. So it's got to be an activity which can be fairly described as commercial, industrial, financial, or
professional or similar.
Professional.
I understand that. And the subrogated claims, would they have come within that definition if they'd been pursued by the parties rather than the state, by subrogated rights, the muscle owners or whoever it may be?
In a sense, it depends where you start. If what you say is that whenever a state is doing something which a private individual could do, by definition it's not acting as a state, then if a private person said, I have suffered damage, I want criminal injury compensation from the liability underwriter of the miscreant, it would still be judicial. But because immunity wouldn't be in question, it wouldn't, in a sense, it wouldn't matter. It's immunity of the state when the state is doing it that matters. So the premise of your lordship's question is, in some respects, trying to find a word that isn't tendentious. It may assume the answer without actually illuminating how you get there. I'm not sure that's a very full answer to your lordship's question, but
Well, it's an answer.
sorry,
It's an answer to the question.
it's an answer. Yes. It's because we're looking at state immunity, in a sense, what a private individual, what rights they have, are only tangentially material in terms of giving colour to what the state has done. But you still have, I submit, the question you have to ask yourself is the asking through the state prosecutor, and it may be that because all the claims were made through the state prosecutor, it may be that the individuals don't arise in this case, but you were asking more generally, I accept that. If a judicial claim for criminal injury compensation comes within the bracketed words, then they do, and that's it, I would agree. The question is whether they do.
Now, I can't see, we had the discussion this morning, whether this point was taken in your skeleton argument.
Yes, I don't think it was. No, I agree.
As I say, so far you haven't suggested that it is. I can't see that it was
It's in the grounds of appeal.
Well, so you say. I can't see that it was taken below, e.g. in your skeleton argument below. Can you...
I'm afraid that is a Joffre Archer ball, my lord, which I'm not in a position to fend off at the moment.
Yes, all right, well,
In all frankness, does it matter? If the point is a good one, and I do suggest, if I need leave to amend a skeleton or whatever, then I will do. But it's only to add a sentence. But in my submission, it's in the grounds of appeal.
Can you just, I'm sorry to hold you up, but can you just show me where in the grounds of appeal it is?
Yeah. Find the right bundle. I think it's core bundle 2. And I think it's tab 20. I've put my two core bundles together, so if I'm misleading you as to which one it is, I apologise. CB 320 it is.
well, if it's anything, it's paragraph 2 on page 321.
That's right.
Which is perfectly consistent with the way you put it in the skeleton argument.
I agree. My lord, if I am not accepting that it could have been done better in my skeleton argument, then I plead guilty to it.
Well, the
question now is whether I can run the point. And if it's a good point, it's a good point. And if it's a bad point, it's a bad point. But if it's a good point, it would be quite wrong in my respectful submission for me not to ask your lordships to decide it.
Yes. All right. Well, at the moment, I'm on whether it's a new point, which may or may not matter. But if it is a new point, we'll have to hear what Mr. Hancock says.
I'm happy with that, my lord. I must confess, I don't think it is a new point, but it's one which my learned friend will doubtless have something to say, and I'm sure he will say that it's entirely not open to me and the usual things. But I say, but yes, I think that's. But you still have to ask yourself: is it of the bracketed characters? And I make the point now. And if I have to reserve it for another court, which heaven forbid, I will formally do so. Now, the learned judge, he was against the states on both awards and judgments claims under 3.1a. So this one actually matters probably more than section 9. And as I say, ironically, it wasn't relied upon in the Court of Appeal below. It is plain, I would respectfully suggest, that Section 3, as we've seen in the Canadian, the Australian, the Israeli statutes, was aimed principally at contracts concluded by states or commercial activities engaged in by states. If a state engages in commerce, then by definition it does not have immunity. That's an obvious proposition, but it doesn't necessarily inform the answer to the present one. A state which signs up to a commercial contract, as they frequently do, which imposes obligations on each party, then the state is subject to those obligations and to enforcement of them by any court that has jurisdiction so to do. That's dealing with the paradigm of the commercial transaction. What we have here is not a contract, and by definition, as the Court of Appeal have held, not a contract, but it is a structure generated by English domestic equity principles. Now, as for section 3.1, the learned judge's reasoning was at paragraphs 60 to 68. And he deals first of all with a point about overlap. And I hope I've made the point that my submissions are not dependent upon any case of overlap. There is plainly overlap between the exceptions, and that is no reason in itself, to apply a limited meaning to any one of those exceptions. But it may illuminate the construction as we have had with NML. Spain's prosecution of claims in the Spanish courts was a commercial transaction, he says. Paragraph 61. The club contends, note those words, the club contends that the continued pursuit by Spain and France of their direct civil claims in the Spanish proceedings constituted a commercial transaction because it was a transaction or activity into which the states entered or in which they engaged otherwise than in the exercise of sovereign authority within 3.3c. Notice it's a contention, my lord, just in case you're interested. I consider that the club is clearly correct in relation to section 3.3c. In relation to this, section 3.3c is very broadly expressed. The claims which Spain and France pursued in the Spanish proceedings were civil claims. Actually, it was done by the public prosecutor, but it doesn't matter. And they were claims for criminal injury compensation, but to that extent they were civil, which in English law
Are you submitting they weren't civil claims?
they were generating claims for criminal injury compensation, which generated a civil liability. So I don't dispute that they were capable of being generally characterized as civil claims. No, I don't. But you have to look and see what the character of the claims is, and it was a civil claim which took the form of a claim for criminal injury compensation resulting from a crime.
Sorry.
But I'm really not wanting to hold your lordships up on this.
And resulting from a contract of insurance without which there wouldn't be any liability
Yes,
of the club at all.
it's not a contract of. I quite agree. That's why I said right at the beginning, I said you shouldn't necessarily think that this was a claim under a contract of insurance. It's a claim which exists because a contract of insurance exists. That was the point I had in mind. So, but my lord, I don't want to be seen to be quibbling unnecessarily about the term civil claims. I'm really not.
Right.
It was just the characterization that I engaged in earlier, which in English law terms constituted an attempt to enforce the terms of the insurance contract. I would respectfully suggest wrong. Enforcing the terms of the insurance contract would involve enforcing terms which didn't exist because of the pay-to-be-paid clause. But for the moment, I'm just looking at his reasoning. Similar claims were also made against the club in the Spanish proceedings, and the judgment awarded to 264 non-state parties. Those other litigants' claims were obviously not sovereign ones, no more was Spain's or France's. The prosecution of such claims thus appears to me plainly constitute an activity which was of a commercial or similar character in which the states engaged. Now, that's the point that I'm questioning. But, and that's the second stage of the learned judge's reasoning. And he says, in the next paragraph, once it is accepted that the continued pursuit of the civil claims by Spain and France constituted the relevant commercial activity, then it is impossible, in my judgment, to resist the conclusion that the present proceedings, both award and judgment claims, relate to that commercial transaction. It is, in a real sense, what the actions are all about. That is the breach alleged, and that is what is said has caused the club's loss and entitles it to the relief claimed. Now, just pause there. It's relief alleged, and I made the point about Rayner. But what he does not do is apply the meaning of relating that appears from Svenska and NML. And that is the next stage of his reasoning, where he says Svenska and NML were distinguishable. As the present claims related, he said, directly to the underlying commercial transaction. And that was, in fact, the extent of his reasoning. At the end of paragraph 63, the actions relate directly to the underlying commercial transaction identified in the way I have done. So his reasoning is incredibly compressed, and I would respectfully suggest fails adequately just to pause on the material points, and in particular the need for the relation, and in particular the need for identification of the commercial transaction in question and the relation of that to the present judgment and award claims. And everything I've said about the award claims and the judgment claims remains in being because of the interposition point that I've already explained. And if, for example, there is no award claim because it's merged into the judgment, then by definition the award claim will the service of the award claim will fail because there's no serious issue to be tried. But it's also because the commercial transaction is itself judicial. Anyway, I don't seek to suggest that the overlap problem is relevant, but he held that the state's continued pursuit of the claims against the club before the Spanish courts was a commercial transaction entered into. And that's not what the Court of Appeal had held. What the Court of Appeal had held was the making of a claim was a claim which fell within the ambit of the arbitration clause, which is a different question. And yet that particular conclusion was both the premise of his conclusion and also the basis of his conclusion. So ultimately, his reasoning was, if I may respectfully say so, circular. He doesn't explain the basis for the premise otherwise than in paragraph 61. And when one looks at section 3, one asks oneself, why has the draftsman of the Act inserted the word commercial at all? If my learned friend is right, and it doesn't have to have any commercial character. Why has the draftsman of the Act in 3.1a added the word transaction? Admittedly, 3.3 has extended or provided clarity to the definition, but you ask yourself, why has the draftsman used those terms? And then when one sees the phrasal verb entered into, one once again may ask the question, why is it something that a state has to enter into? Why has the draftsman used those terms? And it's all redolent of the same notion of commercial activity which we've seen in Australia, Canada, Israel, others. And if the argument is, given that we've got NML and Svenska, which is plainly applicable because of section 3, and plainly against my learned friend because the interposition of the award and the judgment, it takes it outside section 3. You would have to say that Svenska was actually wrong in its analysis of section 3 and related to. Why does it not just say any acts which are not sovereign, which is what my learned friend says it says? But it didn't. And that's because customary international law has carved out commercial activities. And I use the word intentionally, activity, for these purposes. And what is not being done here is colourably commercial activity in this section.
Young, if Australia and Canada and Israel have all thought it sufficient just to use the term commercial transaction, and mustn't we assume that the legislator here intended something further by referring to activity.
No, your lordship is I think they actually came after 78 Act. But I am addressing this point in the context of my learned friend's Ben Carbuche argument. He says that you cannot exclude the right to a fair trial by, well, at all, really. And you can only do it so far as is allowed by customary international law. And I say customary international law does entitle you to exclude liability for things that aren't commercial transactions.
No, I understand that.
I think that's the way, well, I think that's the way I put it. That is the way I put it. Whether I've expressed it very adequately.
No, but you're also asking what the Parliament intended by the use of the words commercial transaction.
Oh, absolutely, and that's section 3.3. I agree.
Yeah.
But the problem is that the bracketed words are sort of the subject of an ellipsis. And I'm just suggesting that not only does related to have the confined meaning given by 4 members of the Supreme Court, but also you've got to consider the content of the passage in brackets when considering the argument about the operation of customary international law. And I just say customary international law permits this sort of exception, or rather permits immunity in this case that isn't otherwise characterized as commercial. And you then say, well, what's the point of those words following the brackets? And entirely
Well,
justified.
before and after bracket. Well, the word activity.
Oh, yes. Sorry, I'm sorry. Yes. A transaction or
And
activity.
you say, on your analysis, there was no point in having the word activity. Was that because it's all a matter of consensual or transaction? Is what you said.
I can... No. I can see that activity may be relevant if, for example, it falls out of the strictly speaking transactional description. But the words of section 3.1a are a commercial transaction entered into, and it's those words which give colour to the way you should construe and apply subsection 3. But I'm only looking at the other enactments in the context of customary international law and my Ben Carbuche argument. I say Svenska. Svenska is the deciding decision and NML for these purposes, and you don't get the sufficient relation because of the interposition of the award and the judgment. It is in the context of the award and judgment claims that this arises. And therefore, Mr. Justice Butcher should have applied Svenska and NML because of the interposition, which he'd already found in relation to the judgment claim, hardly in relation to section 9. I'm going to resist the urge to take you to Svenska and NML, but I think it is probably right just to show you Lamp and Wolf, which is material to the test which is applied. And it's at bundle A, tab 2, sorry, bundle 2, tab 20. Now, my learned friend will say, well, that's case that wasn't anything to do with section 3(1)(a). And to that extent, he is right. That was a case, and I'll Time's Winged Chariot and all that. That was a case where an employee of the United States was suing another employee of the United States for defamation in a memorandum which the defendant had issued. They were both engaged in educational activities on a US Air Force base in the United Kingdom. And although the defendant didn't raise the issue of immunity, the United States did. And there is an oddity in the Act, which derived from the fact that Section 16 appears counterintuitively to remove immunity rather than to apply immunity in those circumstances. And if you're interested in seeing how it works, it's explained by Lord Millett at pages 1584 and 1585. I don't think it matters desperately, but the case actually was decided outside the Act because of the way that the Act had been rather counterintuitively created, and it was decided at common law. But Lord Millett, at page 1587, also deals with section 3. Now, he begins with the words, "This makes it strictly unnecessary to decide the point." And to that extent, yes, it's an obiter, but we all know that there are obiter dicta and obiter dicta. And it is fair to say, my learned friend said, well, Lord Millett was paddling his own canoe, or whatever image one wishes. It's fair to say that at 1577, between B and C, Lord Hope agreed with Lord Millett. At 1578, between D and E, Lord Cook agreed with Lord Millett.
In substance.
Sorry?
In substance.
In substance, but the substance, what they didn't say was, we agree in substance, but we can't agree with what he said about 3. And Lord Hobhouse agreed at page 1581. So Lord Clyde was the only one who didn't formally attach himself to what Lord Millett said. But interestingly, he does specifically say between D and E at page 1579. At just above D, he says, "I'm conscious that in so holding I'm adopting a relatively broad construction of the words related to, but I consider such an approach is correct. If, on the other hand, a narrow approach is adopted, so that the relationship has to be something of a more direct or immediate nature, then I should have thought that the same phrase, proceedings relating to, which appears in section 3(1), would require to be given a correspondingly narrow construction." So he's saying that he doesn't think it arises on his conclusion, but he also agrees it should be given a narrow construction. So the only judge who actually singled out the commentary on section 3 was one who ultimately agreed. All of the other judges said we agree in substance, and I would respectfully suggest the substance of the speech of Lord Millett relates to section 3. So, yep, I couldn't agree more. It's formally an obiter dictum, but it's an obiter dictum coming from the House of Lords with what I would describe as the approval of, in fact, 4.5 of their lordships, not 3.5, further 3.5. Section 3, and this is 1587. In my opinion, he says between E and F, section 3(1)(a) is not satisfied because although the contract between the university and the United States government is a contract for the supply and services, and therefore a commercial contract within the meaning of section by virtue of section 3(3)(a), the present proceedings do not relate to that contract They are not about the contract, but about the memorandum. And that was, of course, you'll remember, Mr. Justice Butcher said, the question is, what is it all about? That's precisely what Lord Millet said he shouldn't do. And one could say, of course, it was about the contract, but it was actually, in that sense, it related in a rather less concise way. It was about the memorandum. The fact that the memorandum complains of the quality and services supplied.
Hold on a moment. Now, Lord Millet is posing the question that's being answered by whether the proceedings are about the contract or about the memorandum, isn't it? That's what
yes.
that he himself is applying.
No, they are not about.
Justice Butcher for that.
Yes, they're not about the contract. They could be said to be about the contract because the contract is what the memorandum related to.
But your submission is that Mr. Justice Butcher was applying the wrong test.
Yes.
When he asked what the proceedings were about in this case. Where what Lord Millet seems to be doing is asking himself what the proceedings are about in that case.
No. What Lord Millet is doing is saying that the subject matter of the action is the memorandum. It is not the contract. Even though it all arose out of the contract. But for the contract, it wouldn't have mattered. And then,
Since you just looked at the clock, we need to finish within about the next 5 minutes.
Yes, that's why that's precisely what I had in mind, my lord. I think if I may respectfully say so to my Lord Justice Popplewell, the fact that the memorandum complains of the quality of the services supplied under the contract means that the memorandum relates to that contract, which is why section 16.2 is satisfied. But it does not follow that the proceedings relate to the contract, which is what section 3.1a requires. In my opinion, the words proceedings relating to a transaction refer to claims arising out of the transaction, usually contractual claims, and not tortious claims arising independently of the transaction, but in the course of its performance, or I would say, of course, because of the award. It's no longer the arising out of the arbitration, it's arising out of the award. And that's what the cause of action is. And as I've said time and time again, one has to identify the relevant agreement for the purposes.
No, the transaction here, if there is one, is the pursuit of the Spanish proceedings.
Yes.
And the award and judgment claims arise out of the pursuit of the Spanish proceedings. And therefore appear to fall within Lord Millet's approach.
I would respectfully disagree, but how much time, if I may ask, my lord?
Well, I think we should finish by 20 past.
Okay, I shall do that. I have no doubt, he says, that the writing and publication of the memorandum constituted an activity of an official character in which the United States engaged through the medium of the defendant, so as to bring the proceedings within section 3.3c. The context strongly suggests a commercial relationship akin to, but falling short of a contract, perhaps because gratuitous, rather than the unilateral tortious act, and that indeed gives colour to the word activity. But even if the defendant's acts of writing and publishing the memorandum can be brought within the opening words of 3.3c, they are excluded by the concluding words, since for the reasons I have given, they were performed in exercising sovereign authority. Now, but what we have there is that the words relating to have to be given a narrow construction, and it has to arise out of, effectively, the relevant transaction, not arise in consequence of. But if the learned judge has applied the right test in saying what is it all about, and if one concludes that he has satisfied himself that there is unquestionably not just a serious issue to be tried, but an actual, proven, legal obligation, so that the breach can then be attached to it, then I'm wrong. I would agree. But those qualifications that I've indicated are very important. And the interposition of the award is what really distinguishes, or the award or the judgment. The merged award into the judgment creates this very distinction which Svenska was there to introduce, saying there is a limit to which one can attach proceedings in this country to a relevant commercial transaction or activity. I'm not going to say anything, at least now, about anything more than I've already said about Ben Carbuche. If anything arises by way of, out of what my learned friend says, I will deal with it in reply. But I will say that I am not asking you to construe the 78 Act inconsistently with the Human Rights Act. I just say that there are certain immunities which, as a matter of customary international law, states are entitled to. And this is not proven to be outside that, the scope of those. 3.1b, I think I've pretty much already said everything I want to say at this stage about 3.1b. I say there was no obligation to be performed in the UK or in England. It was an obligation, in effect, to do nothing at all. And as my learned friend has put it in his skeleton argument, the only obligation was to withdraw the claims in Spain, i.e. performance in Spain. But one asks oneself the question, what was Spain, or France and Spain, bound to do in England? And the one thing, the best that my learned friend can say, is that we were bound to commence an arbitration which we were bound to fail in, because that's what Mr. Schaff had held. So it's a very odd obligation. It's to do something which is completely futile. Futility in a different context. But as for the declaratory relief, maybe it might be, I can deal with that tomorrow. I don't actually want to add very much to what I've said, at least at this stage in my skeleton, and particularly in the light.
All right, well, I think you've, parties have suggested that the first 2 days of this appeal should be devoted to state immunity.
Yes.
You've had one of them. Have a word with Mr. Hancock. I think we must make sure we do finish state immunity tomorrow, because there's other material to get through.
I could not agree more, my lord. I've been, in spite of appearances, I've been endeavouring to cut short my submissions on my notes rather considerably, as you probably gathered.
If it helps, my lord, then I hope that your lordships have received an agreed timetable between the parties.
Yes.
I'm not sure I have.
That Mr. Young would take up today on state immunity. I would then kick off tomorrow on state immunity and leave him 3/4 an hour or so to reply on state immunity.
Well, that's what I was referring to when I said that the parties have agreed to spend the first 2 days on state immunity, and why I suggested that you have a word to see whether, if he needs another 10 minutes or something, that eats unacceptably into your time, or you feel you need every minute you've got. But anyway, either way, we'll resume
I'd much prefer it was the latter, but yes.
All right, we'll resume at 10:30.
I'm sorry I've taken as long as I have.
All right. Now cease the live stream. 90 seconds.